Good afternoon. Welcome back to our Tuesdays with Matt Grumbling with Wen Tarbet, LLC. Matt is a patent attorney, and every week he gives us some great information. We've been through a patent series, a trademark series. Now we're in the middle of the copyright series. And today, Matt is going to be talking about copyright licensing and options for monetizing your creations. If you do, we are, just for everyone's information, we are recording these webinars so that if you have questions or you missed something or you just want to watch it again, you can actually go to YouTube and go to the City of Surprise Economic Development YouTube channel, and you can catch all of these awesome webinars. Hi, Matt. How are you?
Hi, Julie. I'm doing great. How are you?
I'm great. Looking forward to hearing about ways I can monetize my creations through copywriting.
Well, I'm ready to go here.
Okay, I'll turn it over.
Okay, thank you. So today's topic is copyright licensing, and my name is Matt Grumbling. I'm a patent attorney with Wen Tarbet IP. We often go by ntip.law.com. Here's our website here, and we've got my my contact information up here. That's my email and my cell. If you do happen to call my cell, please remember to leave a message. That way I'll know you've called. Sometimes things get sorted into the voicemail without my getting a chance to answer them. So if you would go ahead and leave me a voicemail, I'd appreciate it. So today's topic is copyright licensing, and you know, it's one of the ways, in fact, it's probably one of the major ways that copyright owners make money from their creations. So let me just kind of click in here and start moving along. Today's topics I'm going to give just a little bit of a review from last week, and then I'm going to talk about assigning a copyright, licensing, and then lastly enforcement. And these are all important aspects of monetizing your copyright. You might think to yourself, well, first off, let's start off here with categories of copyright protection. Copyright actually covers a large number of different types of expression. We have literary works like books and magazines and things like that. We have musical works, including any words accompanying those musical works. We have dramatic works, including any accompanying music. So you kind of have a reciprocal thing there between 2 and 3. We have pantomimes and choreographic works. We have pictorial, graphical, and sculptural works, motion pictures and other audiovisual works, and sound recordings and architectural works. You might wonder, you know, if you're in the computer code business, well, where does that fit in there? Well, it kind of fits in there under literary works. It's considered to be a type of writing, and so it would fit in there. It's somewhat controversial, but you know, we have now somewhere around 30 years of pretty good precedent for copyright protecting computer code, especially source code. So what cannot be copyrighted? Copyright does not protect ideas and procedures and processes and systems, methods of operation or discoveries. If they're covered at all, they're covered by the patent law. Concepts or principles aren't, you really can't get any protection for those under the federal law at least. There is, and it doesn't matter how you express these things, these ideas, procedures, processes, whatever. You can't get a copyright on the underlying idea. Now, you know, it's important to understand, though, that if you write a book espousing a certain idea, you have a copyright in the book. You know, the book is a unique expression. I think we talked, you know, last week about what's an original work. It means that you didn't copy it from somebody else, basically, and that it's a work of authorship. authorship has a technical meaning under the copyright law that there has to be some minimal level of expression. So, there has to be some level of creativity involved in it, and things like phone books and just alphabetized lists and things like that really aren't copyright protectable, but just about anything else is. So the first thing I'm going to talk about is assignment, and assignment means sale. So you've created something and you just want to sell it outright, lock, stock, and barrel, not reserve any rights whatsoever. You'll need to do that in writing. You're going to have to figure out how much you're going to value it at. And that's going to be a little tricky. Oftentimes assignments are done with the sale of a company. So you sell you've started a company, maybe you've created some application that has some source code and some compiled code, and you have copyrights in those things. And now you want to sell the company. A lot of times the valuation will be built into the actual value of the company. In many cases, up to 90% of a company's value may be in its intellectual property. So, a lot of times valuation of the copyright is going to be part and parcel of valuation of the company itself. But, you may have a situation where you don't want to sell your whole company, you just want to sell some part of it. You want to sell some or some part of your business. Maybe you've just decided you're going off in too many different directions and you want to spin out something and sell it to somebody else. There you can, sell things, again, lock, stock, and barrel, and you're, figuring out how much you should sell it for is maybe not a trivial thing, but it's more or less a business decision. You can value it at, some sort of a royalty over the course of the term of the copyright. Remember that the term of the copyright is 70 years. It's the life of the author plus 70 years. If it's a joint work, it's the life of the last surviving author plus 70 years, which is nice. If you're going to do a collaborative work, you should find a long-lived co-worker, a collaborator to create that work. That's usually helpful. If it's a work for hire for a corporation or a company, then it's 100 years from creation of the work for hire. You may, there may be some anticipated profit, and you may want to calculate the value of the assignment from some percentage of anticipated profit, maybe paid in a lump sum, or maybe over a course of years. And, it depends on, whether you feel better about it as, maybe you're looking for something that's maybe a retirement or something like that. You might sell it to cover your retirement. Again, these numbers they're a little bit arbitrary. Let's see. Now, this doesn't usually come up, and this comes up more in the patent context. But maybe you can value your computer code looking at some value that it adds to a process, and maybe you can price it out that way. Licensing is a much more common way to monetize your copyright. And you might think, well, I'm just going to sell whatever I'm going to sell myself, so I don't need to worry about this. Well, maybe that's true. You might consider, though, a few things, and we'll talk about some of those as we go through here. But the biggest thing here is, most of the time, and I'll just talk for a minute here about some of the general considerations that you need to take into account when you're thinking about licensing a copyright. Most of the time, you'll be selling a thing, maybe a book or magazine article or DVD or CD or something like that, or maybe it's a web page. So it's not. It's still kind of a thing, and or maybe it's a digital download, and it's going to embody that copyrighted material. You're probably you're going to need to include a copyright notice, and we've covered this before. That copyright notice is basically, I'll show it to you later. The copyright symbol, or the word copyright followed by your name or the name of the company if it's a work for hire, and the date that it was created. You don't need to state that all rights are reserved, although oftentimes that's just something that people do as a matter of habit. But just because you sell, let's say, a DVD to somebody, doesn't mean and you put if you put a copyright mark on it, that's their notice that you're reserving all of your copyrights. You don't need to say all rights reserved, but you can. It's not going to hurt anything. There's really no legal significance to all rights reserved beyond the copyright notice itself. Sometimes you grant a license in something, and it's going to be limited, and I'll spell more of that out later on. Some more general considerations. What are the rights you can grant in a copyright license? Well, you can grant reproduction rights. You can grant the right to make derivative works. You can grant the right to import copies or sell and distribute copies. These are all could be some mix of these. There could be some limits on them. You could have the right to make 100,000 copies. Let's say, first printing of a book, you might grant the right to print 100,000, depending on how that relationship works out. If you feel like they did a good job of distributing your work, you may continue that relationship, or maybe you might reserve the right to go and find another distributor if that doesn't go well. Making derivative works tend to be things like maybe additional editions of the work, maybe you're selling a book and you might give the rights to a stage play or a screenplay. And importation is another thing. And just because you say that they can reproduce it doesn't mean that they can have it done overseas and brought into the country. Those are really separate rights that you can grant. Selling and distributing copies. This is the right. For instance, you might take on the printing yourself, then hire somebody else to do the distribution, maybe through a brick and mortar store, maybe through some sort of sales channel, marketing channel, maybe online, something like that. Then there's the right to publicly display the work, and that would include maybe displaying or publicly performing the work on a digital platform like, say, Spotify or something like that. So these are all different things, and you want to think that through, right? Because let's say you did a book, you might want to reserve the right to do the book on tape yourself, rather than have somebody else do that for you. And you might have just a preference for how it's read, and you might want to reserve the right to do that yourself. Things like that. Let's see, some more general licensing considerations. There's a doctrine in both patent and copyright law that's known as the exhaustion or the first sale doctrine. And what this basically means is that once you sell a copy, you can't restrict the next sale of that copy. Now, there are exceptions. You can actually restrict the license so that there's you're not allowed to, that buyer is allowed to restrict. But in general, the the default rule is that once you sell, let's say I print a book out and I sell it to my friend, and he's free to do with that what he wants to. He can take it out and give it to somebody else, donate it to the library, sell it to somebody else, maybe even at a profit. Those are things, and you can't prevent somebody from doing that in general. Now, again, you could have a license agreement that stipulated that that it had to be sold, that that the article had to be sold to others with with some license restrictions. Software often has those kinds of restrictions in it, and you can, if you feel like it, you can read your if you've got a smartphone or something like that, you can read the license agreement that you agree to every time you click on an update or something like that. You can read through that and you can see what you're allowed to do generally. You're not allowed to make copies. You're not allowed to make derivative works unless, expressly permitted, things like that. Just because you sold a book doesn't mean you lost the copyright. They don't have the right to turn around and make a million copies of your book. There's a distinction between the article, which you exhausted your right to that article once you sold it, or book or CD or whatever, and the copyright underlying it, which you don't give up unless you actually license that to somebody or sell it to them in an assignment. And I've already covered this. The purchaser can sell that copy to someone else, and you can't stop them, but they're not allowed to go out and just print as many copies as they want to. Now, this is a tricky thing here, and this was actually decided a few years by the Supreme Court. What if under a valid license, let's say a distributor you hire for the Asian market creates copies, and perhaps if it's an overseas market, maybe it's priced a little lower than it would be in the United States, maybe a lot lower, and then they bring somebody buys them overseas and brings them into the United States. What if any recourse do you have? And the answer is you don't really have any. Once it was sold under a valid license overseas, then it can be bought overseas and imported to the United States, and you don't get anything more out of it. That's a pretty controversial thing, but Congress really hasn't fixed it. So that's what you're stuck with. I think what that's generally going to do is you're probably going to be less likely to license things overseas at a considerable discount to what they would cost in the United States. So if anything, it's going to jack up the price of copyrighted materials overseas. Probably won't affect the U.S. market too much, but it's something to take into consideration when you're pricing out, say, foreign rights to your copyrighted material. Do you want to give a steep discount, or do you want to make sure that you keep the price high enough so that if it's resold and resold again in the United States, that you're getting your full value out of your license, and you're not sacrificing something by licensing it overseas. And there are, it's just like monetary arbitrage. These are ways of people making money. They look at the disparities in the cost of goods in different markets, and they try to make some profit over that by buying things cheap overseas and bringing them into the United States. Now, if it was unlawfully copied overseas, you still get to, you can sue or you can get law enforcement involved, and I'll talk about that a little bit later. So I'm not talking about unauthorized sales here. I'm really talking about authorized sales. There may be some common law or statutory, and by statutory I mean state protections that mitigate the exhaustion doctrine. Things like privacy rights and moral rights of authors and things like that. I won't talk about those too much this time, but let's talk about some typical licensing situations. One is publishing distribution. These are just some examples: books, CDs, DVDs, magazines, maybe a serialized, maybe a column or something that you write for a magazine or something like that. Software, oftentimes there are distribution agreements for software. You probably, you'll see this a lot. And, even if you want to sell it under your own name, under your own trademark, etc., you may have a publisher who does the publication. Maybe you do the distribution, or you take care of the publishing and then you have somebody else do the distribution. These things have to have sort of an agreement that, it's a contract basically. It says you'll distribute this, and these are the rights that you get, and these are the rights that I'm keeping. And we'll talk a little bit more about some of the actual terms there. You can imagine an anthology or a serial publication. In an anthology, maybe you've written a book of poems and somebody wants to include your poems in an anthology, and maybe they pick certain poems that they want to include, or maybe they want to include all of them. And that's a typical type of publishing and distribution agreement. Adaptations and derivative works. Well, these, we know about books that become movies and stage plays, or stage plays that become movies, or movies that, you can just imagine the permutations there. It could be a short story, and it doesn't have to be a book. It could be a short story that becomes a movie or a stage play. Those are the kinds of things we're talking about. That books on tapes. These are typical. I listened to a series of language CDs a while ago. That shows you how old I am. And they always had the copyright notice on there, and the copyright notice said that the copyright was in the publisher for these CDs, the presentation of the CDs, but it was in the author for the content. So that's not an atypical way to do these things. That they kind of split up the different rights there. So the author had the right to the content and could actually reuse it in a different format, but in that particular format, the publisher had the copyright. Photos and magazines are online. You can imagine, a lot of photographers, freelance photographers especially, they own their own copyrights, and they may license a photograph to more than one publication source, maybe a magazine, and then they'll maybe put out a book, or they'll include it in some wallpaper art or something like that. You can imagine the various ways that can happen. Open source computer programs. Open source agreements are situations where you agree that you will use software code with the agreement that, and the understanding that you will allow others to back license your improvements and whatnot. So you can incorporate this open source code into your own applications, but then you're a member of some consortium. You sign an agreement that said that others will have access to your improvements. And these open source agreements they come in all sorts of different varieties. So in general, though, the folks who subscribe to these generally have a sort of an anti-copyright bias. So they're going to try to skew things toward not covering things by copyright. You can have restricted use of computer programming, and I mentioned this before. You download the latest operating system for your computer. It actually has a number of terms and conditions attached to it, and those terms and conditions are basically limitations on the license that you have. So, oftentimes they'll provide that you can make a single archival copy in order to back up your computer. But there may be any number of other caveats and limitations in there. Like for instance, they might say, well, you can do this on a single device, or maybe you get 10 seats and you can do it that way. Things like that. So here's some common licensing terms. One term that you need to think about is just what will the form of the copyrighted work be? Will it be print? Will it be online? Will it be in the form of a DVD? Will it be in the form of a digital download? Things like that. Maybe there'll be a serialized publication like a magazine. What kind of rights do you want to confer? Do you want to confer the reproductive rights, or the reproduction rights, the right to create derivative works, the right to publicly display or perform the work? Some other things to think about is, what about the territory? Do you want it to be the US only, or some part of the United States? Maybe, everything west of the Mississippi, and maybe give that to one publisher, and everything east of the Mississippi you reserve to yourself, something like that. Maybe you might say that if it's a digital thing, you might limit it, or you might specify that's on the internet. You can do worldwide rights, and then you might want to break that down and have different royalty rates at different in different territories, things like that. Any defined subregion worldwide, right? So you can do Europe, or you can do the European Union, which is a smaller subset of Europe, or there are all sorts of different ways to do this. What will be the mode of distribution? Again, maybe you want to divvy it up so that certain distributor does brick and mortar, and another one that does really well with online sales does online sales, or maybe you reserve the right to do online sales yourself, and digital downloads and things like that. Enforcement rights. Okay. Oftentimes when you're licensing, you're going to have to decide who will take the job of making sure that this copyright is actually enforced. And if you're working with a big distributor, they may already have a stable of lawyers just ready to go to jump on any infringement that they might see. That might actually be a value of going with them. On the other hand, if you're working with somebody smaller, they might say, well, we really don't have the money to get into enforcement. We want you to do that. So these are things that you'll have to work out in the license agreement. So you want the enforcement rights to be exclusively in you, or do you want them to vest in the other party? You want them to be shared somehow. Maybe you'll share the costs, or maybe one has a preference. Maybe there's a right of first refusal on one part or the other. And if sometimes we'll write these agreements so that the owner of the copyright has the first right to enforce, but if they decide not to, the licensee then has the right to enforce. What are the conditions under which the agreement will terminate? Will there be, and you need to cover both, what's considered a breach and what's considered to be, planned termination. The term can be for a period of years. It can be for the life of the copyright. It can be, you know, perpetual so long as certain conditions are met. It can be for a term of years with, conditional extensions and things like that. So these are all things you want to think about. Post-termination. I should mention there, imagine a situation where you license the publication of a book to a certain company, and they also promise you that they're going to try to market it for production of the screenplay. Well, you might actually say, well, you have 10 years to turn it into a screenplay, and after that, those rights revert back to me. You'll still have the right to continue to print the books, but because usually by that time things have tailed off to enough of a degree that you're not going to be making much money from the books unless you can get a movie deal, in which case the sales of the books will probably kick back up again, right? So you might want to say, well, I don't know about your track record. I don't know if you'll really work that hard to sell my idea as a movie. So I'll give you 5 or 10 years or something like that to do that, maybe even a shorter period of time. And if that doesn't work out, then those rights will revert back to me, and I'll get all the money for it too. Let's see, and then what happens post-termination? You might have, there might just be winding down of the relationship. If it's a distributor, they've printed 100,000 copies, and the end of 5 years has come. Do they destroy those copies? Do they sell them back to you? Do you or do they continue to have the right to sell them until that first run is completed? If it's really popular, they might, if they anticipate that it might turn into a series where we have a number of sequels, they might agree to sell, let's say, your book with either an option or a commitment for you to create additional works. A lot of pulp fiction type of writers write under those agreements where they agree to crank out a certain number of books in the series, and then presumably they make more money that way than they would have if they had to sell each one of them separately to a separate just publisher and distributor. There are some other terms that might pop in here, and some of them are common law terms or statutory terms under state law. And these are things like privacy rights and publicity rights and rights in characters. You create a new comic for a big comic book distributor. They may want to own that character, and of course, you'll bargain for how much you can. Because maybe they want to own the character, maybe they want to have somebody else, be able to continue the series even after you've ceased having interest in it or the ability to continue with that series. So you can also bargain to sell them those rights as well. And then there are just all sorts of contract rights. Just general you can agree to just about anything in a contract, as long as it's not what we call unconscionable. It's that basically the contract can have anything you want in it that you and the other side agree on. So those are just some basic thoughts there. The next thing I want to talk about here is enforcement, because when it really comes down to it, making money on your copyright is going to depend an awful lot on whether you can keep others from knocking off your copyrighted work and underselling you, right? So one of the values of a copyright is it's essentially a monopoly on your particular work. So how do you enforce? Well, one is that and I've said this before, and I'll say it again, mark whatever the work is with a copyright notice. So here, my example is copyright 2021, writer, the author, or you can use that copyright, the circled C. Either one of those will do. That puts the buyer on notice that this is covered by a copyright, who owns the copyright, or who at least who owned it in the first instance, and the year that it was the year that it was first created. So, and again, you don't need to put in all rights reserved. That's understood under the law. The first the first thing you're going to need to do is, watch out for people violating your copyright. And, it's easier said than done. You're going to need to monitor various sales channels. Probably, if you really make it big, you're probably going to, whether you make it big or not, you're probably going to want to get on on the various sales channels, digital sales channels, and maybe even, print sales channels, and look at what's being offered. And, make sure that, not to pick on anybody in particular, but somebody isn't selling your copyrighted material without a license on, say, Amazon or something like that. Not that they would ever do that, but you have to police that. Once you discover that somebody is violating your copyright, or if you suspect it, then you would send them what we call a cease and desist letter. And what a cease and desist letter does is, and just like in patents, it lets them know, now you've already got a copyright notice on there, so they have what's called constructive notice. You want to give them actual notice that they're infringing. And what that does is it starts the clock ticking for enhanced damages. So, if they continue to violate your copyright after that date, then they're not just liable for the copyright infringement, they could be liable for enhanced damages for willful infringement. You can send them a notice letter, you can send them a licensing offer, say, hey, we notice you're doing this. Looks like you kind of know what you're doing. How would you like to, have a license to this? If you still have that, if you haven't licensed it to somebody else already. Then the next step up is the cease and desist letter, where you basically tell them, stop it, or we're going to take action. And, and I say beware the declaratory judgment. So declaratory judgment action is basically an action by the accused infringer to shut down your attempts to enforce your copyright. That is, I'm not sure how likely that is to happen in a copyright context, but it could happen. And the value that they get from filing that kind of judgment, a declaratory judgment action, is that they get to pick the venue. So they can pick where they want to have the suit actually fought out. Now, continuing on enforcement, so you can file a lawsuit in United States District Court or in state court, and it needs to be either where the infringer resides. It needs to be where the infringer resides, and that you're looking for actually for copyright, it can be where the infringer resides, or it can be actually anywhere else that you can get personal jurisdiction for them. So thinking about it in an enforcement context, you could sue them in any district court or state court that it's convenient for you to sue them in. If they are U.S. residents, then you can sue them anywhere where they're actually committing the tort of copyright infringement. So this actually should say infringer resides, or anywhere else you can get personal jurisdiction. And usually the laws of the states are pretty expansive on that. But you can definitely get them where they reside, and you can sue them in their state of incorporation or where they have a principal place of business. But you can also sue them in other places as well. And oftentimes, the copyright owner will try to find some place that's really pro-copyright, and with good reason. So then the next step is probably most lawsuits settle, and usually there's some sort of a licensing agreement that comes out of the settlement. The settlement might be, we dropped the suit and you promised to never ever do this again. And so that's that kind of exhausts your own personal sort of self-help things that you can do. But you can also actually, it turns out that the federal law makes the copying and distribution of copyrighted materials a felony, punishable up to 5 years in prison for willfully, for commercial advantage or private financial gain, distributing or reproducing within 180 days at least 10 copies or $2,500 worth of copyrighted material. So, that's where, your notice letter actually is very nice, because it puts them on notice. And then, these are pretty low numbers, really, when you look at 10 copies or $2,500 worth of copyrighted material. Those are pretty low, and you can get the FBI involved for, if they're basically doing more than just a de minimis type of copying. And there are limitations on that, but if it's really a commercial threat to your business, it's not a bad idea to get FBI involved. And the way you do that is by you report the suspected violations, with whatever evidence you have, to the FBI field office. They'll investigate. They'll make their own recommendations for criminal enforcement to the U.S. attorneys. Then there's Customs and Border Patrol. So if you register your copyright in the Library of Commerce with the Register of Copyrights, and then you register your copyright with the Customs and Border Patrol, and you can then submit allegations of violations to Customs and Border Patrol. And they'll actually look out for it. If you give them kind of a description of what your copyright covers, they can look out for infringing articles. This is really common with trademark infringement, but it also works in copyrights as well. And finally, you can enlist the help of the International Trade Commission. And under the Tariff Act of 1930, importation of an article covered by a valid copyright is an unfair trade practice. And that's under 19 U.S.C. 1337. So what you need to do is, once again, register your copyright with the Register of Copyrights in the Library of Commerce. And you can file a Section 337 complaint with the International Trade Commission. And the ITC will complete its investigation within 45 days. And by statute, that's their requirement. And what they can do for you is they can issue an order excluding the accused works from the United States. And it can be enforced by, again, the Customs and Border Patrol. So this is very helpful. They'll not only seize them, they'll destroy them as well. So those are your options for licensing. I hope this has been helpful to you. And Julie, I'm going to hand everything back to you now.
Great, thank you. That was very informative as usual. So we thank you for your time. As I mentioned before, this episode or this webinar is recorded, so you can go back and watch it again. You have Matthew's contact information if you have any questions, and we will see you back here next week, same time, same place, and we will be talking about copyright pitfalls. So Have a great afternoon, and thank you very much.